Okay, a federal judge has blocked a California law that would restrict the ability to conceal carry across the state. Now, the law originally barred concealed carry in sensitive areas, quote unquote. Places like parks, sporting venues, and educational institutions. The U.S. District Judge who blocked the restriction said parts of the bill unconstitutionally deprives concealed carry holders from their rights to carry a handgun. In a statement, California Governor Gavin Newsom said the complaint and the ruling defies common sense. He signed the measure into law in September. In the meantime, the state's attorney general plans to appeal the federal judge's decision. And joining us now to further weigh in on this issue is Executive Director of the San Diego Gun Owners PAC, Michael Schwartz. Good morning, Michael. Great to see you.
Good morning. Thanks for having me.
This was good news.
It was very good news. And, you know, in no universe was this a common sense gun law. This was extreme. The governor is completely off. He's extremely wrong on this. And there's two important points I really want to point out. One is we're talking about people that have gone through the training and gone through the background check so that they can obtain a permit and carry outside of their home so they can defend themselves. The other thing I want to point out is that it's already illegal to carry in places like schools or airports or courtrooms. Those are sensitive areas. What he did with this law is he made every place in California a sensitive area. Retail stores, grocery stores, churches, private property, you name it, it was a sensitive area. There's nothing reasonable about a complete and total ban. It's totally unconstitutional. And this judge that ruled against it really emphasized that point. He's a very reasonable judge. He has an excellent history. And he came out and said, wow, this is really bad, and actually described it as repugnant.
The methodology, the ideology of what the governor is trying to do is if we can get all the guns, we're going to have this, you know, sugar plums and lollipops. And the reality is that's not how things work. And to your point, background checks, training, gun range tests, written tests, people are qualified.
No, taking the ability from people who are sane, trained, and law-abiding to defend themselves does not stop crime. In fact, if you look at a lot of the mass shootings that have made the headlines across the nation, well over 90% of them have been in a gun-free zone. In other words, an area where you're unable to defend yourself, you're unable to carry a firearm for self-defense. So his response is to make the entire state a gun-free zone. That doesn't make any sense at all. I really wish they'd spend taxpayer money on defending our rights and liberties rather than trying to take them away, or at least going after criminals that will harm us rather than going after normal, everyday Californians who are just trying to defend themselves.
To your point, the Aurora, Colorado shooters, I understand, there were 8 other theaters in that area. He chose that one, gun-free zone.
Time after time, if you look at some of these horrible mass murders that have made the headlines, which are horrible and tragic. They're relatively rare, but they're horrible and tragic, and everybody wants to see an end to it. But time after time, they've skipped over a place that was guarded by people, good guys with guns, and they've gone for some place that they know they're not going to have any resistance. You know, you're never going to see a mass shooting at a gun store, right? It's always going to be at a place where people are unprotected. And there's story after story of people that have actually stopped a mass shooting or put a halt to a mass shooting because they had the most effective self-defense tool ever created, a firearm.
A couple of months ago, we had a mass shooting on the East Coast, 2 locations. Both were gun-free zones. The weekend after that happened, I interviewed a woman, I can't remember her name, but she is the president of the National Police Officers Association. I think that's what it was. And I asked her specifically about these gun-free zones, and she immediately said that is the dumbest thing you could ever do, is have an establishment that's a gun-free zone. Now, bars, things like that, the places we don't carry, like you said, airports, federal buildings, places like that. But she said the bartender in one of those establishments tried to get the gunman with a knife and ended up getting shot and killed. She said, imagine if he could have protected himself with a firearm.
Yeah, last year the Supreme Court ruled that, hey, you can't have these subjective requirements in order to get a permit so that someone can defend themselves outside of the home. And the governor really threw a fit, and this is a result of that. It's a reaction, an overreaction to that. And he's way off base. He's not following the logic. He's abusing his power. This goes way too far, and we're seeing law enforcement didn't support SB2, the law that passed. Nobody really does. It's very unreasonable. Just the extreme fringe, or people that don't understand what we're trying to do. So again, we're not changing this ruling. It isn't going to change existing gun-free zones or sensitive areas. What it does is it stops the governor from turning every place in California into a gun-free zone, which again, totally unreasonable. Doesn't stop crime. Certainly leaves people less protected, not more protected.
The Supreme Court has made its decision, as you just mentioned, but the governor still wants to enact his own way, despite that decision, and that's really the head scratcher for me.
It's concerning, and there are a lot of other pieces to SB2 that are overreaching as well. One of the other examples is that the state has come down with requirements for instructors to be CCW or carry permit instructors, and there really isn't much of a path. It would have left San Diego with less than a third of the instructors that it has, to get people their permit. And so sheriffs across the state are refusing to enforce that portion of it. They're saying, hey, California Department of Justice, SB2, governor, this is ridiculous. It's completely unreasonable. We're not even sure it's constitutional, but we certainly can't follow it, so we're not going to until you provide clarification, and the clarification needs to be logical and sensible, and we need to be able to get people through the process so they can get a permit. So the sensitive areas part is just one piece of the fight. We're continuing to fight the rest. But it really has, again, this judge has an excellent background, an excellent history. He's very reasonable. He's right down the center. But even he went very far in explaining that, hey, this thing is an affront to the Constitution. It is way overboard. And again, he described it as repugnant. We're so glad that he saw that, and we're going to continue to fight the fight. And I know we're going to win.
Okay, Michael Schwartz, appreciate your perspective.
Great, thank you.
Great seeing you.